Okay, picture this. A serious incident just went down at your workplace. The clock is ticking, rumors are starting to spread like wildfire, and honestly, the legal and financial stakes of mismanaging your next steps are absolutely massive. Welcome to this definitive explainer on conducting internal investigations. Look, whether you're dealing with a minor mishap or a major headline-level allegation, exactly how you handle the inquiry process dictates whether your organization resolves the issue smoothly or ends up in a highly publicized, costly legal battle. Let's get you prepared. All right, let's dive right into this. Here is our roadmap for today. Number 1, assessing the allegation. Number 2, the inquiry officer's duties. 3, gathering evidence. 4, the final report. And 5, filing a police report. Section 1, assessing the allegation, the first response. So, this is the immediate aftermath of an incident being reported. It's the critical window where your earliest decisions are made. But before we put on our detective hats, we really need to know exactly what we're dealing with. So, what is an administrative inquiry? Well, fundamentally, it's an official process to discover the facts about something bad that's happened. It's an investigation, sure, but here is the key difference. It is not for the purpose of law enforcement or criminal prosecution. Instead, its entire purpose is just to gather facts and relevant evidence, basically to provide a solid baseline for management to figure out what, if any, action to take next. Which brings us to the crucial first question you must ask, and it's a big one. Do we actually need a formal investigation? It sounds super simple, right? But rushing into a full-blown probe isn't always necessary. While on the flip side, ignoring a major red flag can be totally disastrous for a company. The rule of thumb here is actually pretty straightforward. Err on the side of investigating. Now, in a few rare situations, like say if the problem appears to be very minor, or if literally all the employees entirely agree on what just happened, you might reasonably decide, hey, a full investigation is overkill. But usually, failing to investigate a serious issue is just inviting legal trouble and lingering workplace toxicity. Sometimes you just can't tell how widespread a problem really is until you start poking around. Section 2, the inquiry officer's duties, taking the lead. Once you decide an investigation is absolutely necessary, somebody has to run the show. Enter the inquiry officer, or IO. This person carries a really heavy burden of impartiality. Their very first duty to verify that they or any appointed panel members do not have any personal, professional, or financial conflicts of interest. We're talking about checking for things like co-authoring papers together, direct supervisory relationships, or any financial ties that could cloud objective judgment. The IO also has to inform the respondent of exactly who is on the panel and give them 5 working days to object. And time is literally of the essence here. The whole inquiry should generally be wrapped up within 60 calendar days, unless you've got some very well-documented special circumstances. So, the crucial point here is balancing the investigation with the rights of the employee who's actually in the hot seat. It's a delicate balance. During this early stage, the employee actually isn't entitled to be fully informed of the specific charges yet. They do, however, have the right to representation if they reasonably believe discipline might come down the pipeline. But, and this is a big but, they do not have the right to legal representation unless the investigation might lead to criminal prosecution. Now, if answering questions could expose them criminally, they absolutely can exercise their right to remain silent. But remember, management still has the right to manage its workforce. An employee can actually be removed for refusing to reply, provided they are adequately warned they are subject to discharge and clearly told their replies cannot be used against them in a criminal case. Section 3, gathering and evaluating evidence, finding the truth. Okay, this is the operational core of the inquiry. It's time to roll up our sleeves and figure out what actually happened. The most basic way to gather information is, well, just by asking questions. You absolutely must conduct unbiased interviews in a quiet, private space. Use open-ended questions to get as much information flowing as possible. And speed really matters here. You want to conduct the full inquiry fast, ideally within 2 to 3 weeks for volatile situations, not just for the sake of efficiency, but because you want to lock down stories before interviewees attempt to influence other witnesses. Let's look at how this builds into formal documentation. You cannot just rely on your memory or some scribbled notes. You need a rock-solid written record. When taking a witness statement, you have to put the interview into a first-person statement using the exact words the interviewee used, not a summary, their exact words. Have them read it over, allow them to make any changes they want before signing, and always, always give them a copy of the final document. And this brilliantly illustrates the gravity of what we're talking about. Every single witness statement should close with this exact phrasing. I hereby certify under penalty of perjury that the following is true and correct to the best of my belief. This isn't just a casual water cooler chat. Signing off on this literally locks the witness into their version of events and ensures they fully grasp the seriousness of the process. Once you have your signed statements and all your physical documents, emails, personnel files, maybe even photographs, you have to evaluate the whole shebang. Honestly, this is often the hardest part, especially when witnesses completely contradict each other. You have to ask yourself, whose story logically makes the most sense? Whose demeanor was more convincing? Does anyone here have a clear motive to deceive you? You have to weigh everything carefully. And look, sometimes, despite your absolute best efforts, you might just have to hold your hands up and acknowledge that you don't have enough solid information to decide what really happened. Section 4. The Final Inquiry Report, documenting the findings. All right, so you've done the interviews, you've gathered the evidence, and now you have to synthesize all of it into a clear, actionable document for management. Your final report is what protects the company from future liability. It explains exactly what you did and why you did it. It needs to follow a highly specific structure. Start with the subject and the background. Then lay out a meticulous list of exhibits and witness statements. This leads right into your statement of facts, where every single fact you claim must be supported by one or more of those exhibits. Finally, you lay out the investigator's conclusions. Following this format leaves absolutely no room for ambiguity. So where does this report go? It goes to the disciplinary authority, or the DA. The DA reviews it, along with any comments from the respondent, and then they make the final call. Do we close the case entirely, or do we initiate a much deeper investigation? Now, if the case is closed with no finding of misconduct, the DA has a massive responsibility to take reasonable steps to protect the positions and the reputations of everyone who was involved in good faith. You have to minimize the damage to reputations that might have resulted from inaccurate allegations. That's a huge part of the job. Section 5. Filing a police report, lodging the FIR. Up until now, we've dealt strictly with internal administrative matters. But what happens when an incident crosses the line into an actual, cognizable criminal offense? Well, this is when we must lodge a First Information Report, or FIR. Now, what's really interesting about this is the distinction of who exactly should be filing this report on behalf of the company. Very frequently, organizations will just send a security executive down to the local police station to handle it. But police will often refuse this. Why? Because the FIR must be lodged by the officer directly concerned with the commission of the offense, meaning the aggrieved party or the direct custodian of stolen property. A report filed by the direct victim is considered an undoctored FIR, and it has immense legal value because it's a first-hand account. If an unrelated security guard files it, it creates massive, inherent weaknesses during cross-examination in court, simply because they cannot directly corroborate the facts. The actual legal process for lodging the FIR under the Criminal Procedure Code is highly specific. You provide the information orally or in writing to the officer in charge. If you give it orally, the police must reduce it to writing and literally read it back to the informant. The informant then has to sign it. And most importantly, by law, you are entitled to receive a copy of this recorded information forthwith, completely free of cost. Because this one document sets the entire criminal law process into motion, you absolutely must take strict precautions while it's being recorded. First, it must be recorded at once. Any delays have to be properly explained in the FIR itself. Ensure the police use the informant's exact words without inserting their own ideas or trying to minimize the financial loss. You need to ensure the exact time, any injuries, and descriptions of weapons or clothing are noted meticulously. And if any corrections are made on the physical document, they must be properly initialed. But what if you do everything right? You follow the steps, but the local officer in charge just flat out refuses to register your FIR? It happens. Luckily, the law provides a very clear remedy. If you are aggrieved by a refusal, you basically take the substance of the information, put it in writing, and send it by registered post directly to the superintendent of police. If they look at it and are satisfied that a crime is disclosed, they are legally obligated to investigate the case themselves or direct a subordinate to get it done. Wow, okay, we have covered a tremendous amount of ground today, right? From assessing that very first initial complaint, to properly gathering evidence, all the way to navigating the complexities of the police reporting process. So, I want to leave you with this final critical thought. If a major crisis hits your organization today, are you truly prepared to act objectively and legally? Because having a structured, legally sound investigation process doesn't just solve problems, it literally protects your people, your reputation, and your company's entire future. Keep this explainer handy, make sure you structure your internal teams properly, and you'll be ready for whatever comes your way. Thanks for joining me on this explainer, and I'll catch you next time.